goes by the YouTube handle Asshole Report.
Stay away from me, lady! Stay away from me! Get this lady away from me! Get her away!
Man, that man's whole fucking report, dude, is such a fucking goof.
Okay, Peters!
What's your mission?
My mission right now is to keep you from harassing small children.
Or we can start asking you why you need a bigger bra than Kate does.
It's me, Kate. You know, masshole Kate, date of your existence Kate, your every night obsession Kate.
I targeted you because you're a pedophile. That's usually how that works.
She's just trolling him one way or the other.
I was the constitutional law scholar today, bitches.
It's like going to war with a fucking nuclear power that has lost its fucking mind.
I'm here to be a spectacle, not a role model.
Welcome, everybody. Sean, Merv.
Welcome. Hello, Mafia.
Yes, so got a few things lined up. Naturally, it's let's talk about Chille night. This is for Blue Butterfly. She loves talking about Chille. It's like her favorite person in the world. So she asked us to do a stream on Chille in tonight. I don't know what her obsession is with them. It's just weird. So Merv is with us. Merv is the big brain on the panel. We always need you, Fairy Goddess. For those who don't know Merv he's very humble about his education. I think Merv's extremely smart. He actually, I know. That's what gave me like $25 in donos to say that kind of stuff about you. So Merv is actually an attorney out in California. I'm not going to give too much of his pedigree, but like I said, he is an actual practicing attorney in California. Whatever he wants to share, he's more than welcome to share. So we'll give people a chance to filter in, and we're going to talk about guns and gun laws and restraining orders, and we're going to play some Chille videos about Chille's understanding of protection orders and some other stuff. So anyway, welcome everybody.
Thank you.
Yeah, anytime. So what is your take overall of Chille? I've seen some of your videos, Merv, and your videos are excellent, breaking down some of his legal understandings or lack thereof.
Well, I don't like to play much in drama. I don't know if you could tell that by my videos. I like to more talk about what the legal aspects of things are. And Chille, there's a phenomenon in the law where sometimes people can say things that are so stupid that it's really hard to start trying to break down what they're saying and why they're wrong. People like Beware Mouse have that issue. And Chille also has that issue. He says things that sound like they mean something, and they have meaning, and he throws them out in a rapid fire manner, connected by ums and uhs. And when you actually stop to look at what he says, it didn't mean anything. He just threw random things out. So that's my take on Chille. He's learned enough of the lingo that if he throws it out fast enough, and if you don't know what he's talking about, it might sound like he knows what he's saying, but he has no idea. He has no idea what he's doing. Just none. That's my take.
That's kind of the motive with a lot of these auditors. Josh Abrams is infamous for that. He'll come up and just bombard you with words. Now, I'll give Josh a little more credit. I think Josh is smarter than Chille. But at the same time, he'll come up and just, like you just said, give you word diarrhea, throw all kinds of stuff at you, and overwhelm you. And it sounds like he knows what he's talking about. I'm assuming you've watched Chille in court both times.
Surprisingly enough, most of my practice is, well, not most of my practice, a large amount of my practice is dealing with civil and domestic violence restraining orders. And I have had it was really fun when I first started doing it, sitting in court and listening to all the weird and crazy shit that goes on. But since it's what I do for a living, it's not, I don't want to come home and watch it, honestly. I have heard brief summaries of them. Like I heard that Chille prepared all sorts of case law that dealt with criminal civil harassment restraining orders in Massachusetts, which why you would do that, I don't know, but he did it. So I've heard things about it, and I can talk to you about the things I've heard and where he went gravely wrong?
Horribly wrong. That was it. I mean, it's again word salad. He thought he did his due diligence. I've listened to 3 of his trials. There was one in Arizona. There was that he again lost miserably, and then there was a 2 in Mass that he lost miserably. Michael, thank you very much. I appreciate it. It's just he's a petulant child. When things don't go his way, he instantly throws a temper tantrum.
So if I could just say my understanding of the legal process in California, to get your temporary restraining order in a civil harassment or domestic violence or elder abuse, all you have to do is allege facts sufficient enough that if they're true, they would warrant a restraining order. The bar is so low that all you have to do is say the right things. I'm going to assume that since the first hearing was ex parte, that the same kind of standard applies in Massachusetts. That's an assumption. It's not legal advice. With that said, if he failed to get a temporary civil harassment restraining order, whatever they call it out there, that means that he's either incompetent or what she's doing is so not civil harassment that even just saying what she's doing, assuming it to be true, it's not going to work. So it's just real fail if you can't get the temporary. That's the level of fail we're at. You can't even say the right words that if a judge just has to assume they're true is going to write the order. That's how bad it is.
And it's pretty close. Apparently Massachusetts has 3 levels of restraining orders. There's the ex parte, as you mentioned, that if it's that egregious, they will grant it right away. I apologize. I can't remember the second one. The third one was where they have a 10-day hearing where both parties can show up and present their evidence. And during his presentation for the ex parte, he was literally all over the board. I mean, he did not have anything lined up whatsoever. And then when I believe it's a Harry Balls show. No, Kate. Yes, delete Law's mouth pipe. It is a Harry Balls show. No, Kate. So during the initial ex parte hearing, he was literally all over the place. And then when he didn't get his way, he literally threw a temper tantrum at the judge, and it just didn't go well at all. And they literally shut him. He went in the courthouse. I guess the courthouse closes at 4:30. He went in at 4:20, demanding this hearing for the protection order. They humored him. From what I understand, they actually at one point had to handcuff him because he was throwing such a temper tantrum. And then he got his way, and then the judge said, fine, bring him in, we'll have the hearing. He didn't get what he wanted, and the judge said, we're going to have a 10-day hearing and give Kate a chance to respond. So that's where that went. So fast forward 10 days. Naturally, Kate kind of went on. Oh, and she also told him he demanded to have a video hearing in Mass. And the first judge said, no video hearing whatsoever. You must show up. And that's what started his temper tantrum. And he started asking the judge questions. Why can't I have a video hearing? Why can't I have a video hearing? And the judge said, I'm done. Have a good day. Ruled and walked off the bench. So fast forward 10 days. He comes to the hearing, and Kate he gives his spiel. Again, he's all over the place. He's making unfounded accusations, blaming Kate for everything except for the Kennedy killing. As you know, I'm sure you've seen the channels. There's probably a good 25 or 30 channels out there right now. Literally, pardon my language, just shitting all over Chille. I mean, he's like the new toy of YouTube, and he's being passed around like a crack whore at a party. And it's fun to watch. I mean, everyone's making videos of Chille.
Yeah.
So he comes up and he's such a pompous ass. He starts quoting these laws or these rulings to the judge. I'm sorry, I'm getting way ahead of myself. There's been so many videos. Back to the initial hearing, he gave the judge the video of the parade, and he only wanted the judge to watch his part of the video. And when the judge wanted to watch the whole video, he's like, no, there's nothing there. Please, go on. And kept telling the judge what to do. And the judge was like, no, sir, I am going to watch the whole video. And he literally kept interrupting the judge. And as someone mentioned, would have been nice had she, taking a recess, went back to her chambers, watched the video. But like I said, it was 4:30. They all wanted to go home. They all hate this guy. So she's trying to get through this. Mm-hmm. So now back to the second hearing. He's stating all these case laws that, again, some were criminal, some were civil, some were in California, some didn't apply to what he was going for whatsoever. And he's making all these accusations, and they're just strictly unfounded. And the judge basically, said that it was her First Amendment right. She was doing the same thing. When the ruling came, it was funny because Josh was in the court as a witness for Kate. And Kate went to call Josh as her witness, and you can see the blood drain from Chille's face. That it wasn't going to go well for him at all. And Sean, jump in if I'm missing any highlights here that you think are pertinent. Or Matt, I'm sorry. When he found out Josh was...
I go by many names.
Yes, you do. So when he heard Josh was in the courtroom, he literally lost his shit. And you can see that the blood was...
I wouldn't say he lost his shit, but I would definitely say that his soul drained out of his chest into his feet, along with most of the blood in his face. He definitely went white as a ghost, started chewing a hole in his lip, and was displeased. We'll put it that way.
And you were in the courtroom, correct?
Yeah, I was physically there, and that's when it started going downhill, and it was kind of like a boxcar at the top of a grade on a railroad. Once it started rolling, it just kind of went out of control, and until it completely went off the rails, put to an end only by the court clerk and the judge ending the Zoom call, and then or ending the Zoom session mid-sentence on him. Which, by the way, Merv, if you've seen the video of the Zoom call, that's not actually where it ended. In the courtroom, he went on for another good 2 minutes until the clerk finally slammed the whole video off. And I think had he kept going, he probably would have accused her of being on the grassy knoll. So, along with the judge being the son of Sam killer and a few other things. It started downhill when he saw Josh, and it was abundantly clear that he intended to try and call Josh as a witness himself. And that was where it started going downhill, and it was off to the races from there.
Well, let's kind of back up a little bit. We skipped over a good portion of what happened. So the judge makes his ruling, and then Chille literally loses his shit at the judge. Luckily, if he had been in court, he probably would have been held in contempt. He got his Zoom hearing. From what I understand, how he got the Zoom hearing was, again, what happened was right before he left Massachusetts, he went down to the clerk's office and said, "Listen, I got this going on. I can't be in the state. I must have a hearing, the Zoom hearing." So the clerk of the court said, "Fine, we'll give you a Zoom hearing." So once the judge starts ruling, and the judge kind of seen the writing on the wall. So the judge takes pause and says, "Here's why my ruling is the way it is." And he breaks down every point that Chille was making, and he addresses each and every one of those points. And he states Massachusetts law as well, no federal law, just Massachusetts state's law of why he's making this ruling. And then you see Chille mute his phone, and he starts yelling at his phone, which we think was Joe Hart he was yelling at. And he comes back on, and he starts yelling at the judge that this is a kangaroo court. You were doing this because she's a copsucker. You're doing this because you don't like me and you like her.
Well, hold on. I got to back you up there because we are skirting over some stuff. So he loses his soul when he finds out Abrams is there to support Kate. It then continued downhill as he began making arguments using case precedents, which only applied where there were criminal charges. They did not apply in civil cases. The judge instantly, from the look on his face, recognized that. He then started getting very upset that the judge kept asking him questions instead of listening to him. He also started to get very upset when Kate started her rebuttal and pointed out several things that he had done, including the fact that he had on stream threatened her with a lawsuit and a cease and desist prior to him getting there. So Kate was being truthful that he had claimed he was going to serve her. He was very upset when Kate pointed out the information about him and firearms, to which his response was, "This isn't about me. I'm not on trial."
He wasn't.
Well,
No.
he wasn't, but it was a factor. And he also got extremely upset when Kate brought up his warrants and his history of running from warrants, because Ohio is actually not the first one. He faced a false identification lying to police in Benton County, Oregon. The only reason he wasn't convicted of that is because he ran from it, and it was gone so long out of the state that eventually it became part of an administrative cleanup where they just started quashing a whole bunch of warrants that were on the books. Cases that weren't worth going after. Basically, petty misdemeanors, driver's license, traffic offenses, things like that.
The Oregon one, the false identification, is that where he was driving a car with stolen plates?
That was one of them. He had a couple incidents in Oregon. He lived there for a bit. We also found out during his III that apparently he has a conviction for disorderly conduct, harassment / stalking in 1993 in Ohio that nobody knew about. Allegedly, if the judge read that properly. So it started to build up and build up and build up and build up. And the judge said, "Okay, Chille, send me the documents you have, send me the case law, the evidence you have." And Chille screwed up and admitted that he was live streaming without the authorization of the court and in violation of the Massachusetts wiretapping law to his Signal group. The bailiff, who happened to be the same one who restrained him in the initial hearing, caught that, brought it up to the judge. He quickly denied it, but it turned into a thing. Basically, he tipped it off by saying, "I can't send these to the court because it will end my live stream." He actually said it like an idiot. So the bailiff called him out. Eventually, the court clerk sent him the email address, said, "Send them here." Judge said, "All right, 2-hour recess, send them in. I'll look them over." Go outside, 2-hour recess, get a soda, smoke a cigarette, so on. At which point he contacts Josh Abrams. "Congratulations, you just contacted the defense witness." The judge did not appreciate that, though he didn't bring it up. It was a benign message, but nevertheless still inappropriate. That's also where we found out he had messaged it to, or had been live streaming to Signal, that was actually a thing. So we go back in, and very, very little happened initially. There was a little back and forth, some more questions, clarification. And Kate kept trying to call Josh, but the judge he kept glossing over it. It became pretty clear he had a fairly clear picture of what was going on and what had to happen. Kate stuck the dagger in Chille's side when he kept interjecting, and Kate actually put in a hearsay and a relevance objection, both of which were sustained, and that really pissed Chille off. And the judge went literally, as Harry said, point by point by point, every single element, cited the correct mass appellate court case law. He did claim to have 3 witnesses, 4 if you include the fact he intended to call Josh. On the phone was Joseph Hart, Joe Orga, real credible witness. It's always a good idea to call somebody as your witness who's currently under investigation by Alphabet Soup in DC. And the judge, as he read it, Chille just started getting more unhinged, started going off the rails even harder. And when the judge ended his ruling, that's when he started to go off on the judge and say, well, I bet you'll love it when this happens to you. Or if this happens to you, it's a kangaroo court. You're doing this because she's a woman, because you like him. And it got really intense. They ended the Zoom stream, the Zoom hearing, but the Zoom call kept going. So for another 2 minutes in court, we're just watching him lose his ever-loving mind. And they clerk got up, finally ended the call, and the rest is history. Though I do want to point out too, again, the bailiffs who were in the courtroom were the same bailiffs that he had not only abused, but had restrained him. And when Kate made mention of that, and this will forever be one of my favorite parts of the whole day, both bailiffs standing in the back of the room raised their hands so the judge could see them and pointed at themselves. They wanted to make sure the judge knew that, hey, this is fact and it was us, and screw him. Yeah, and that's basically the summary. So sorry for going on, Harry, but
no, that's fine.
Wanted to...
So now you're up to speed. I also added Paul Carroll to the stream tonight. Paul is actually a assistant district attorney out in Ohio.
Enemy.
He's the enemy of my enemy.
Yes, even to other lawyers, I can still be the enemy.
Oh, is that Merv? Yes. Yeah, Merv's defense, you're the prosecution. This could get fun all of a sudden. Maybe we'll wake up now. So Merv and I were talking before the stream started, and we were talking about Chille's restraining orders in California. Now, from what we understand, and I wish Kate could come up because I don't have the paper handy in front of me, these were civil protection orders, not criminal protection orders, and that's why they're not showing up possibly in NCIC or III right now. But and correct me if I'm wrong here, Merv, from what you were saying, that this protection order prohibits him from owning, possessing, purchasing a gun anywhere in the United States under 18 U.S.C. 2266.
So the California Domestic Violence Restraining Order prevents you from possessing or purchasing. You can still own them, but you have to turn them over to law enforcement or someone else. So you can own them; they can be yours, but you can't actually possess them. So they can't be in your house or anything like that. And 18 USC, I had it up, 2266.5 means that every other state has to recognize the validity and they have to enforce every other state's restraining orders. So a California restraining order is enforceable in Ohio, and the terms of that restraining order are also enforceable in Ohio. And the restrictions against possessing or purchasing firearms are applicable in Ohio. So yeah, he would be in violation of California law and federal law by possessing a firearm in Ohio.
And that even goes for private sales.
So private sales, you cannot sell, to the best of my understanding. I'm not an expert on this subject at all, but to the best of my understanding, private sales are illegal to out-of-state residents, just period, as a matter of federal law. California requires that residents of California purchase through an FFL, and they have to pick up their firearm through a California FFL, which will do a California Department of Justice background check on it, in addition to the federal background check. So Chille is currently a resident of the state of California, and therefore he has to purchase it in compliance with California law. And so he has to purchase and take possession the firearm through an FFL in California. So yeah, he can't do it through a private party transfer.
And I do have the paperwork in front of me, so I do just want to affirm for the record that the one restraining order is a general jurisdiction domestic violence protection without minor children.
Real quick, she was asking, what is an FFL? FFL stands for Federal Firearms License, and basically that's all gun stores within the United States. if they want to sell a gun commercially, they have to have an FFL license. If you sell X amount of guns per year, to whether it's private party sales or whatever, you must possess this license. If you do a one-off, like let's say I wanted to sell a gun to MERB, I could sell a gun to MERB, no problem, without a license. But if I go to a gun store, any gun store must have an FFL to sell me that handgun. Now, here's what's scary about Chille MERB, and I kind of briefly talked about this to you before the show when Chille's understanding of protection orders, and I kind of want to share this and get your opinion and get your thoughts, because as we know right now, gun laws are a huge touching spot throughout the U.S. No matter what side you fall on them right now. And Chille's kind of scary. And like I said, well, let's watch this video. It's a 5-minute video of Chille's understanding of protection orders. And we'll come back and we'll dissect it some more. Let's see. Share screen. I apologize. It's been a long time since I've done this. Chrome tab.
It's all right. We'll be gentle.
Thank you, sir. I appreciate it.
Is this the same troll that followed me the other day?
Can you guys hear it?
Yeah.
Okay.
Yes, sir.
Is that what this guy is? Because if it is, I think that's the same guy that hounded me the other day. I think it is. There he is. I think that's. What's your name?
Bill.
What's your name, Bill? Bill what? You're terrified. You're a coward. You're a bitch. How about that? I'm calling you a bitch to your face. I think you're a fucking pussy. How about that? Oh, yeah. I think I could throw you on the ground in 2 seconds flat. Yeah, turn the music up to avoid being identified. This guy's a coward. You're a coward. What's it like to be called a bitch to your face like that? Get out of the car. See how you do. Step out. Yeah, that's what I thought. I'm not the guy that you play games with when it comes to the legal system. Why do you think I don't grab that little pipsqueak out of his heart and pop his head off like the little bitch that he is? Why do you think I don't physically grab him and choke the shit out of him? Why do you think I don't do it? Not that I don't want to. I want to grab him and choke the shit out of him. Why don't I do it? It's illegal. Can anybody identify this guy? I'm going to go in the light so that he'll come around. And then I want to identify him. I'll file a restraining order against him first. And then if I see him again, I'll defend myself with physical violence. And so what I'll do is I'll file a restraining order against him first. And then after that, that gives me a right to defend myself with violence. That's a fact. You can't put someone in fear for their life. And then if I see him outside of his car, I'll get to throw him on the ground. And then I'll have to go to court, and that's fine. But I filed a restraining order against him for the harassment he was doing. I don't have to run from that man. If I'll get a restraining order against him, and then after that, then I can beat the shit out of him. And it's just that simple. I can beat the fucking shit out of him. And just so you know, I like fighting. I enjoy it. So unless you enjoy it, I would be very careful. After I get the restraining order, I can literally kill you. I'm not kidding. I'm not joking. Now, I'll have to face trial for that. But if you stalk and harass me and put me in fear for my life, and I get a restraining order on you, and then you show up and I blow your head off, what happens next? You had been stalking me. I'll have to face a manslaughter trial, but clearly you put yourself in that position. And I don't care. I don't mind one bit. So I just want to be clear. And so I just want to I want to see that guy one more time so I can file a restraining order against him. Because if he shows his face around me, then I have to believe he has ill intentions. And I carry a gun. So if I feel like I'm in fear for my life, I'll do what I have to do to protect my own life. If I get a restraining order against you and then I see you, gun comes out. It's that simple. Let me tell you what a restraining order does do, though. If you get a restraining order and then that person shows their face, I have a right to get my gun and defend myself. Then the next time I see him, if he ends up getting shot, it's not my fault. I asked him to leave me alone. He put me in fear for my life. It's that simple. It's that simple. And don't think I won't blow someone's head off. I will. If you force me into a situation where I have to feel like I need to defend my life, I will blow your fucking head off in 2 seconds flat. You don't get to stalk me and harass me and stalk me. That's not how it works. And once I get that piece of paper that says you've been restrained, if you continue to stalk me, then the next step is I'm going to defend myself using my Second Amendment right. That's why I carry a gun. Because if you make me where I need to defend my life, then what happens next is that could be it for you, because you forced me into this position. And it's just that simple. Listen, and I don't think you guys understand. I would sleep like a baby. If someone decided to be stupid and do something dumb, I'd sleep like an absolute champ.
This guy is the picture of why red flag laws are written.
Well, I think the first thing the first problem is don't do meth. I mean, I'm not joking. I mean, you shouldn't be streaming while you're doing whatever drug you're doing. That's got
to stop boofing cocaine.
He's talking way too much, way too long about stuff. But the other thing is, I'm sure Paul as DA loves this kind of stuff where people talk all this shit before they commit a crime or before they shoot something, because everything that he said is most likely going to be admissible. If some harm befalls that poor fella who he was harassing or wanted to harass him or whatever, then I mean there's this wonderful record available for everybody to see of Chille expressing his intention of wanting to go shoot this guy and beat him up and hunt him out. That's I think really where the problem is, that he I mean, it's fine if you're really scared of someone, you get a restraining order and you're actually making the effort to distance yourself from them. You're like, hey, I don't want anything to do with them. And you don't go seeking them out and they go seeking you out. Well, then, things happen and you have a right to defend yourself. But you can't seek them out. I mean, that's not a thing.
Paul, would that raise it to first-degree murder at that point?
I mean,
which state?
Yeah, that certainly makes a difference.
Well, let's pose the question this way. Would it sufficiently, in both of your opinions as defense attorney and ADA, would material like that be sufficient as to go to mens rea, to criminal intent?
That's a good question. I mean, I'm sure the prosecution would want to admit it as evidence of intent and premeditation, and I'm sure that I would want to keep it out. I do want to say that my criminal experience is very limited. I've never done a murder case, I've
never done a murder case either.
But I'm sure that prosecution would love to get that in.
Right, and what premeditation can really come down to is like how many seconds, how many minutes before the actual act of the taking of the person's life occurred, how much of that time can be accounted for? What kind of process can you demonstrate to a jury to show that this person thought about it enough ahead of time and then still decided to commit the act?
Right, whether it was heat of the moment, passion, or like I said, literally premeditated.
Yeah, and
like
it,
in this
it
case,
could only be a matter of minutes. Like this is a story of my father's, who is also an attorney, but he actually got put on a murder jury way back in the day, and it was a question of a kid biking by one of his classmates at a bus stop, sees him, goes around the corner, gets a gun, and then within maybe 5 minutes comes back around and shoots the guy at the bus stop. But that period of time, even though it was very short, was still enough where they were able to demonstrate he rode past the guy on his bike, got the gun, turned around and came back. And those actions together all amounted to premeditation. So
I would suggest it doesn't even have to be a matter of minutes. It could be a matter of moments, as long as there's some clear-headed thought that's going on that you can demonstrate. It could be something as simple as you know, you're really upset with your spouse, you walk over to the safe, it's a manual entry on the safe, you take the time to put in the numbers in the dial, open the door, get a gun out, load it, and shoot. That might be enough. It might be enough, depending on circumstances, to show premeditation.
Yeah, or even you like the stereotypical situation of the guy comes home and sees his wife in bed with another man. If he has the gun in his hand, puts the gun down on the counter, then picks it back up again and shoots, that could certainly amount to premeditation. So it's really very much attuned to the specific circumstances of what happens.
So let's go to... I'm sorry, I didn't mean to cut you off. Paul, go ahead.
I was just going to say, the entire time that Chille talks like this, it just strikes me as hilariously disingenuous, because on other live streams, he rails about how he, quote unquote, doesn't feel fear, and how he grew up in the fire of a fight or whatever he says, and how he's not afraid of anybody. But then in circumstances like this, he's talking about how he's put in fear for his life on a pretty regular basis anytime he encounters another human in these towns that he's auditing in.
Now, going to the other end of the spectrum, let's say that he did kill somebody now that he had a restraining order on. Naturally, I'm assuming this video would be admissible. And based on his statements during this video, would that make it premeditation?
Your hypothetical is unclear, and one of the things I'd like to caution you on is a lot of times hypotheticals will never completely, you'll never be able to really give a good answer, because so many things come into play, like the credibility of the witnesses, the quality of the evidence. You know, there's just so many things that you can't really give in a hypothetical. But if you clarify who has the restraining order and who's getting killed.
Okay, fair enough. I mean, I'm just playing devil's advocate. Let's say that he got he's made this video, and he's now out of Ohio, and he's in Mass. And let's say this judge, for whatever reason, did grant him that restraining order against Kate, harassment restraining order. And then let's say Kate shows up at another parade, and Chille breaks out his gun and just shoots her point blank, no questions asked, and says he was in fear of his life.
What, like if Kate was doing, if Kate was minding her own business, and there was some, so in my assumption, I don't do the charging, so I guess I would defer to Paul on this. I mean, would you start from the top and work your way down on the charge?
Probably. I mean, you would have to look at the specifics of the situation. You know, if somebody has a restraining order against somebody else and they both show up at the same parade, and the person with the order shoots the person the order is against across the street where they clearly didn't pose any physical danger to the person, yeah, that could certainly warrant charging the person who did the shooting. But
I mean, the use of force, the amount of force, it has to be reasonable and necessary.
Right.
You can't just say, I'm in fear of my life, I'm going to shoot you now.
Yes, their mere presence at the same event, especially if it's a large public gathering, doesn't necessarily create reason for the person to use violence to defend themselves.
And obviously there would be a consideration for the local laws, correct? Like Ohio is a stand your ground state, Massachusetts is a duty to retreat state.
Right.
But even it doesn't matter what state you're in, the force has to be reasonable and necessary still, even in stand your ground states. And Florida proved that, and Florida is one of the most lenient on stand your ground cases. There was a case about 4 years ago in Clearwater, Florida, where a rather large black man pushed a small white guy down on the ground. All he was pushed and shoved him, kind of like Chille did to Kate. The guy fell on the ground, pulled out his gun, shot the guy. Guy claimed he's in fear of his life, pulls it and shoots him in the chest, and the black guy dies. They actually charged that guy, and he was convicted. So, like I say, again, the force has to be reasonable and necessary, not just because you say you're in fear of your life.
Right.
I'm just a first-year family law attorney, but I mean, you could be in fear of your life if you're a little guy and you get pushed down by a big guy, and you don't know what the intent is. I mean, you could reasonably be in fear of your life. So I'm sorry, I keep putting the defense hat on. It's hard for me.
No, it's fine.
And the reasonable person's standard is also, they call it a term of art in law school, where it means different things to different people. What is reasonable to Chille may, and I would argue probably isn't the same to everybody else. So if he believes that his fear is reasonable of this person who rickrolled him getting out of his car, if he did actually have the restraining order, may not be reasonable to other people. And certainly that could be a question for a jury.
That definitely would be a jury question.
Oh, yeah. Now, would those be considered fighting words of what Chille did to that guy when he walked up to that guy's car?
Fighting words is a theoretical. It's an exception to the First Amendment. So it's not. There's no specific thing like, oh, these are fighting words. Like I get to do something. Fighting words is an exception to First Amendment protection. First Amendment theoretically doesn't apply to fighting words. So, and fighting words is something that is based on the speaker and the listener. So, like for example, a black guy at a rap concert throwing out the N-word, probably not fighting words. A white guy at a rap concert throwing out the N-word, probably fighting words. So that doesn't mean that he gets to get his butt kicked, although it most likely would end up with him getting his butt kicked. But what it means is that particular language isn't protected by the First Amendment. So theoretically, the state could put restrictions on that particular speech and enforce restrictions against that particular speech without the First Amendment coming in to say, wait a minute, the state can't do that.
Mm-hmm.
So
and to really demonstrate how circumstantial the fighting words qualification is, the Supreme Court case that originates from, I forget the name and even the year that it occurred, but it was at a time when calling somebody, what was it, a damned fascist and racketeer constituted fighting words. Whereas today, if you called somebody that, they would be like, whatever, and walk away. You know, even the specific words in that case in today's day and age would not constitute fighting words.
Okay, fair enough.
So where you see fighting words generally is in like disorderly conduct statutes, where the state can criminalize words that would tend to cause an immediate breach of the peace, tend to cause a fight to break out, in other words. So the state could, so someone could be arrested, for example, for a disorderly conduct in a state that criminalized speech that would tend to cause an immediate breach of the peace. The state could arrest like a white guy for shouting the N-word at a rap concert, whereas they probably would not be able to arrest a black guy for shouting the N-word at a rap concert.
How about the provocation? Let's say for plain stuff, and I know you hate what ifs, but let's say that guy in the Rickroll car got out and just beat the shit out of Chille. He knew Taekwondo and he just rolled Chille up like a bag of chips and threw him away. Would that constitute provocation on Chille's part by going out and getting in his car, basically?
What state are we in?
Denial.
Pretty much.
That was in Ohio.
State?
I will say Ohio. We'll say it was in Paul State.
I mean, it's entirely possible. A lot of that stuff will depend on how good of an argument both sides can put up in court, if it came to that. Chille really demonstrated in that video that if somebody were to use the exact language that he used against that guy at Chille, sure, he may very well throw a punch at the guy for that, because he's got the fragilest masculinity I've ever seen in my life. But again, to a reasonable person who isn't Chille, that may not be the case.
And not to go backwards, but I do just want to point out real quick that in the matter of DeCastro v. Peter, and it still blows my mind that's a thing, the judge actually did hold that nothing Kate said, it was part of the reason why he lost the order, nothing Kate said was, and I quote, true threats or fighting words.
Right. Kate's never made any direct threats at him. Going to Bruce Gordon's question here, as far as I know, there is actually no federal law for domestic violence, non-domestic non-domestic restraining orders or domestic restraining orders. That does not fall under federal law criteria, from what I believe. That falls on state and local. Federal can enforce the restraining order if, say, the person crosses the border and they're with the person they have the restraining order on. They can detain that person and find out if that state wants to extradite that person to where the court order was issued. But as far as and either one of the attorneys, please correct me if I'm wrong, there is no actual federal law for restraining orders. Well, I guess there might be, actually.
I think Bruce's intent with the question may have been: does the federal government, Paul and Merb, in terms of enforcing any or handling arrests, transfers, anything like that, with state restraining orders, differentiate between a domestic and a non-domestic restraining order in how they handle them?
The full faith and credit 18 U.S.C. 2265 whatever applies 66 to restraining orders generally. I think there's a couple of them in there. I think it's like a section somewhere in there, but it applies to civil restraining orders, which would be domestic violence and civil harassment and elder abuse and whatever your state calls them, as well as criminal restraining orders. It deals with both. And as far as to whether, so like that's kind of a weird, like the thought of the federal government having restraining orders for like domestic violence and non-domestic violence. I think technically they could for tribes on tribal land that haven't adopted their own set of laws. I believe there's the Bureau of Indian Affairs has some CFRs that prescribe like a baseline set of laws, and there might be restraining orders in those.
Could be.
Yeah, the only other circumstance I could think of would be if, like, in DC or even Puerto Rico, because at any time that you're getting a restraining order, if it were me, it would be myself, a resident of the state of Ohio, seeking a restraining order against another person in Ohio, or if, I guess there are grounds for restraining orders based on internet activity, it could be against somebody else. But if I needed it enforced, I would call the police in Ohio or the police in wherever the location of the person is, and those would be state police as opposed to the FBI or any federal law enforcement agency.
Well, actually, Merb brought up a point also, like NCIS, I imagine could, CID probably could on military installations. I imagine they could. That'd end your military career pretty much instantly if you're convicted. So
I have dealt with domestic violence restraining orders that dealt with military personnel. So I don't know if that was just because they lived off base or what. But as far as Navin Johnson, First of all, you'd have to spell your contract correctly. We'd have to have a meeting of the minds, and I think your contract would be void because it's against public policy. And also, we never clarified who you would be killing. So I just don't think there's a meeting of the minds. I don't think we'd have an actual contract.
Touche, Naven, touche. So, Merv, you've heard Chille.
Unfortunately.
Yes, bloat about how he's going to take the California State Bar and be a peer of yours.
Yeah.
Now, I've done nominal research on the California State Bar. California is one of the few states that you can get away with not going to law school under certain strict criteria.
Yep.
You have to practice under a judge or an attorney for X amount of years, X amount of hours.
You have to apprentice under, not practice under.
I'm sorry, apprentice. Yes, I apologize. And they have to give you a letter of recommendation. You also must pass the background investigate or the mint. Oh, it's sort of the
MPRE.
Oh, yeah, the what's what I'm looking for to make sure you're of sound mind and good character, moral turpitude background.
Right.
Now, when I read on the California State Bar site that the moral turpitude background investigation takes roughly 6 months before you can even take the test. Is that correct?
So I can only talk. I'm not an expert on this.
No, I understand. But you've been through it, though.
So yeah, I've been through it. I took the state bar first because it'd been a long time since I'd graduated from law school. I took the state bar first, and then I signed up for the MPRE, the Mandatory Professional Responsibility Exam, and I had to take that second. And then the third thing I did was the moral turpitude background check. Now, there's no test involved with that. The only real thing that you have to do is basically cough up all of your information, give up your fingerprints. You have to get fingerprinted through live scan. And most importantly, you have to have a letter of recommendation from a practicing attorney, which I think is going to be a big hurdle for Chille. So he would not get to sit for the exam. And unfortunately for him, most sovereign citizens and people like Chille get really myopic. They look and they see, Supreme Court rulings, everything Supreme Court, federal law. And a California State Bar, believe this or not, has a lot of California law in it. When I was fortunate enough to take the very last 3-day exam. So my testing consisted of 6 essays on where they give you basic fact patterns, and you've got to figure out causes of action or what criminal liability someone may have, all sorts of different things, ethics. They have all sorts of different things that have absolutely nothing to do with federal law. So that's problem number 1 for them. Then there are 2 tests called California practice exams, I think they called them, where they gave you law that was law for someplace like Hyperborea or someplace that doesn't exist. And they give you a fact pattern and they make you work from this law and the fact pattern to give them some result. Like, oh, you're a junior attorney and they want you to write up a list of potential liabilities for this particular transaction or whatever. So you have to use the law that they provide, which has no basis in reality, and the fact pattern that they provide to come up with the answers they want. And then the third thing is that they test you on is called the multi-state bar exam, the MBE. It's where they give you sections of fact patterns, and they ask you multiple choice questions. And these aren't based on California law or federal law. They might have California law questions, and if they do, they'll state that it's California law questions. It might have something to do with federal law, and if it does, it would state it. But by and large, it's common law kind of stuff, things that most states tend to do, theories of law that most states tend to hold. And so you have to pick out the right answer, and they're not easy necessarily. I mean, if you're good at it. But anyway, my point on this is that almost none of that has anything to do with the Constitution or Supreme Court rulings. Very, very little of it deals with the Supreme Court rulings and or the Constitution. So Chille would be completely unequipped to handle that. And then the next step is the multi-state professional responsibility exam, and that has absolutely nothing to do with the Constitution, just 100% nothing to do with it, and you have to pass that. So I mean, his theoretical claim, I mean, let's just assume it to be true. Let's be charitable. Let's say he has been studying the Constitution for the last 20 years. That's not going to get him even 20% of the way through the California State Bar. And I'm sure Paul has similar experiences.
Right. There's a reason there are specific bar preparation programs. I took Kaplan because that was offered through the law school that I went to. But yeah, I mean, just like Merv said, you have essay questions and you have a lot of multiple choice questions. And the thing that I always was kind of irritated by is that when you're in law school, you study very much for the law school exams. Then when you get out, you're studying for the bar exam and you study very much for the specific bar exam. And then when you get into the practicing world, not really a lot of that knowledge that you studied for in your tests translates directly to operating in a law firm or working for the government like I do. Like there's still a lot of separate learning about the actual practice of law that you get when you go to work in the legal field.
There's a difference between the theory of law and the actual practice of law, and it's important to have that theory. I just want to be clear about it. I don't want to denigrate the system too much, because if a client comes into you and says, this is what's going on, you have to be able to, okay, what are we looking at? What potential defenses do we have, or what potential theories of recovery do we have? And you can walk through the steps in your head, and that's important. But day to day, the grind of practicing law is mostly rote. There's not a lot of new under the sun. There's practice guides that you're in pretty much daily. There's judges' bench books that you're in pretty much daily. You're doing forms. You're doing kind of basic things. So it's learning that. It's learning the procedure that's kind of the shock, because the law school they teach you for kind of...
They teach you how to think like a lawyer.
They teach you how to think like a lawyer. The bar exam tests your general knowledge on the law to be able to practice your way, or to come up with the right ideas on how to get results. But then the actual, the worst thing in the world is when you actually become an attorney and all of a sudden you face your most dreaded enemy of all, the clerk. Mm-hmm. You will learn to hate the clerk. The clerks suck. They suck. There's actual appellate decisions in California about how it's hard enough to be a lawyer without having to fight against the clerk. I mean, so yeah. Sorry.
Now, would that in California include the appellate decision that resulted in file on demand that Chille attempted to use in Ohio?
I made a video about filing on demand, which is, I think, what he attempted to use. And I wasn't actually trying to say that this is exactly the way you do it. I was saying that this is how you can do it in California. For some things, if you walk in and they say, well, you haven't done this right, you could say, well, no, you have to accept it. Just accept it. Now, they don't always have to accept it. There's sometimes they have to accept it and sometimes they don't. But by saying file on demand, they're most likely going to say it's not worth my time and hassle, and they'll send it to the judge. And judges usually at that point are like, oh, whatever, I got it, and it's fine. Let's just roll with it. The problem nowadays is that most post-COVID, most attorney filings have to be online. You have to use e-filing, and the clerks aren't. You can't just stare at them from across the counter and be like, look, are you practicing law? So now they're much more likely just to boop, hit a button and kick it back, and you got to jump through their hoops.
Sorry, real quick, Paul. That does not actually exist in Ohio, does it?
In Ohio, it doesn't. That would have to be specifically for California, to my knowledge.
Yep, because the reason I brought it up is because Chille tried to use that on the advice of Bobby Law, and to my knowledge, that
Well,
came out
Bobby
of.
Law is not an attorney either.
Oh, I know. But the reason I brought it up is just because, Murd being here, and to my knowledge, when they tried to use that, they came out of, not at risk of sounding like Chille, but something I actually researched and know, came out of California, Voight v. Superior Court 201, California Appellate 4th, 1285, which was interesting that he tried to use that in Ohio. So I just wanted to get your guys' opinion on that.
Now, California has something called the baby bar. Can you speak towards that at all, Merv? Because I didn't quite understand the difference of what that encompassed.
So if you go to a non-accredited bar, a non-American Bar Association accredited law school, like for example, there is one in Sacramento called Lincoln Law School. Then you have to take, at the end of your first year, you have to take what's called the baby bar. And it's an exam to make sure that you learned enough of the basic stuff, because they teach you a lot of the basics in the first year. Like they teach you con law, they teach you legal writing, they teach you torts, civil procedure, real property. They teach you a lot of the basic stuff. As far as Lisa's question on the would a California attorney lie and say that Chille had apprentice under him, I believe they actually have to turn in basically like timesheets to show like ongoing turning in timesheets to show that this is how much the apprentice has worked at the law firm this particular period. And I don't think they could just at the end of it say, oh yeah, we've got enough hours. I think it's an ongoing process. So it takes years to get it done.
Yeah, I mean, I looked at the statistics, and before I ask this next question, did you pass on your first time, Merv and Paul?
Yes.
Merv or Paul?
So I actually did not. I missed passing my first time by less than a single point, and I'm pretty confident the reason for that was because I was also working a full-time job and studying at night, because I went to law school at night.
Mm-hmm. Good answer. So I looked at the California statistics for the Bar Association. Going into an accredited school, 50% fail the California State Bar the first go around, and that's going to an accredited school.
They changed the bar passage rates. I think in 2021 they changed them up to make more pass. Yeah.
Oh, did they? Okay. I think I looked at 2020, and they were saying the ones that did not go to accredited schools, 95% of them failed the bar the first go around. Yeah,
it's rough.
It is. From what I understand, California is one of the hardest bar exams to take in the country.
Was.
Okay. So they kind of put it on a bell curve now to get more passing scores.
So I took the bar exam in Minnesota, and I think they offer a July and a February exam. I think the July exam actually had a passage rate of like 60 to 70%, and the February exam had a passage rate of 50%.
Can I tell my law school or my bar story?
Absolutely.
Okay. So I've been working. I graduated from law school in like 2000, I think, and I decided I wasn't going to be a lawyer. So in 2016, I finally changed my mind. I'm like, I'm going to be a lawyer. So I signed up for, I think it was Kaplan or whatever, and I studied for the February of 2017 bar exam. It was the last 3-day bar exam, and I studied my balls off. I mean, I worked. I dropped from full-time work to part-time work, and I mean, if I was not working, I was studying. So I go into the first day. You go in. It was at the California Civic Center Auditorium, giant auditorium in Sacramento, and they tell you where you go. You can't have a digital watch. You can't have a mechanical pencil. I mean, they're just like on you about all this stuff. I mean, it's really strict. And I wasn't going to use a laptop because I was just afraid it was going to break down. So I was a pen and pencil guy, and I go in there and they direct you to where you're sitting. I go to where I'm sitting, and there's a proctor for every like set of tables. And so the proctor goes, "Oh, you're new." And then she goes to the next person. "Oh, hi, Tony, 5th time. Well, this one's a charm. You're going to make it. Oh, hi, Susie. Oh, you're going to make it this time. Oh, hi, Jenny. Oh, you got this, girl. You look good this time." And I was like, oh my God, I'm going to die. So, so the bar exam, it starts up. They say, okay, so you're going to have the first set is going to be, you've got 3 essays. 3 essays, 3 hours. You get to divvy up your time. When we say go, you break the seal and start writing. We'll let you know when there's 1 hour remaining, when there's a half hour remaining, 15 minutes, 5 minutes, 1 minute, and then you got to put down your pencil. If you write after that, you're done, you're out, you're gone, right? So I'm like, okay, I got this. So they say go, and I open up the first. Oh, I know this. And I start writing. Go the second one. Oh yeah, it's great. The third one. Oh yeah, great. I'm on the last paragraph of the third one, and the gal up front says 1 hour remaining.
Oh, you're like, what have I done?
Oh fuck, I'm dead. What did I miss? What did I miss? And I'm like, I gotta go back. I gotta figure out what I missed, because obviously I can't be done if it's 2 hours. And then I'm like, okay, all right. They say don't go back. We're just gonna go with it. We're just gonna go with it. I finished up it. I turned it in. Everybody's staring at me. Everybody's staring at me as I'm walking out. They come out for the lunch break, and like no one wants to talk to me. Talking about answers I didn't give. I'm like, oh my God, I'm dead. I call my wife, and when I'm sitting there eating my sandwich, I'm like, I failed. I failed this first part, but that's fine. I'll just take it again. It's no problem, right? I'll just take it again. I'll count this as a practice. Go back in. The second half of the day is the California practice exam. Again, I'm out like 45 minutes early. At this point, I'm like, you know what? Screw it. We're just going to go through the practice every single day. The next day, out 45 minutes early on each one. The last day, out 45 minutes early on each one. I go home. I'm like, okay, it's done. We'll, get back to normal, and I'll just sign up for the next one. So it's like a month or 2 months later. I don't remember exactly how long it was, but they send you an email. And the email says, log into your California State Bar webpage to see the results. So I'm like, okay, all right. Your heart's racing. You can't hardly type in your password. You get in there. And I swear to Christ, it said you got, there's a letter, click on it. And it says, you have not failed the bar.
Oh my God.
Oh my God.
What the fuck does this mean? Pardon my French. I call my wife and I'm like, I can't even read this. What does this mean? And she's looking at it. She's like, I think that means you passed. I'm like, no, it says you failed. Wait, no, that was the most messed up experience. But yeah, that was my bar exam. So
nice.
You can tell the people at the California Bar Association are dicks by phrasing it in that way. You have not failed.
Right.
Because
you're reading like every third word. You're reading
experience in my life.
Yeah, so you're reading every third word. You failed.
Yeah,
that's a masterful troll right there.
Yeah. I mean, personally,
being a lawyer.
Yeah, I mean, I'm not a psychologist by any means, but I don't see how Chille could pass the moral turpitude background.
He can't.
And I was saying this to somebody else. I would honestly, at this point, be more interested in watching Chille do a mock bar exam under strict scrutiny testing conditions than I would be to see him fight Chad Gu, and to have the results actually like done by a bar exam grader and then published before he has a chance to try and spin them one way or the other. Because if he was actually subjected to that test, I think I don't know if his ego would be able to protect him from the blow of not passing when he's claimed for so long that he's been studying to take this exam.
Yeah, it's not, you can't. So I remember before I went into Kaplan, it'd been forever since I'd been in law school. And I remember I bought a study guide off of Amazon, and it was the study guide for that year, and it's supposed to be complete. And I remember looking, and like it was all Greek. It was all Greek, and it was Kaplan really where they actually like kind of started breaking it down. And then once I got in, okay, it all started to make sense again. But I couldn't imagine not having any law school experience and not having someone there to kind of explain the little things, because lawyers, we use words weird. We use weird words in a weird way. Like everybody's like, oh, cops have no duty to protect. Well, that means something very specific. It means something very specific. And people don't understand it because we use words in a different way than they. And so if you're just trying to get into it and you're trying to read these, like you're trying to read decisions or something like that, it's hard to do. And so I wouldn't expect anyone, especially not someone who's too proud to ask for help. I wouldn't expect anybody just to get it outright.
And the Castle Rock v. Gonzalez case that Chille loves to claim is the one saying cops don't have a duty to protect you. I've pointed out to multiple people that the circumstances around that case are much more specific than Chille's vague, broad, sweeping statement like that. The court specifically pointed out the fact that the woman was trying to bring a 14th Amendment property-based claim, and that's what they ruled against, not saying, oh, the police can just ignore somebody who's in dire need of assistance.
And this actually brings up a really good point, because Harry and I, as well as others, have talked about this, and that's the fact that Chille constantly only reads the syllabus of Supreme Court cases. Can you guys talk about how much of a mistake that is and how misleading that could be?
So syllabuses are actually quite useful in doing legal research because it gives you an idea of what the case specifically talks about, but then you do have to go into reading the minutiae if it is a case that you want to read. Like if I'm doing legal research for a brief and I have a specific concept that I need to do research on, the syllabus may very well be able to tell me whether this case could or potentially could apply in that circumstance. And then if I don't think it does, then I won't have to waste my time reading the entirety of the case to get that. So syllabuses are useful, but when you are trying to make broad legal statements like Chille tries to do, if you don't read the entire case, it's pretty easy for somebody who has read it to point out, oh, no, you didn't actually read the thing.
I think Chille's problem is beyond that. I'm not entirely sure that he reads the syllabus, because I think he bases his understanding on the oral arguments. If I was a betting man, I would bet Chille doesn't like to read. I don't think he's much of a reader, and I'm not trying to poke fun at him, but he relies very heavily, from the few times I've managed to sit through his videos, he relies very heavy on the oral arguments. And the oral arguments, they're very interesting if you understand what's going on, but they're not the holding, and they're not the rationale that the court uses. And I just want to state once again, I've been an attorney now for a whole year. I've been a family law attorney for one whole year, for a few years now. And I have never had to use a United States Supreme Court case, period. When I've done my very few criminal defenses, they have practice guides, and California has a robust set of rulings on everything that the Supreme Court has ever made a ruling on, narrowing down the Supreme Court decision to apply to more specific fact patterns. In family law, in everything, the Supreme Court sets like this baseline, but then all of the other courts go in, they fill in all the cracks. And if you're having to go back to a Supreme Court decision, you are blazing new ground, my friend. You are on untrodden territory.
It will just amaze me that everyone that he perceives does him wrong, I'm suing you. It's like he's got to be the most litigious person I've ever seen, ever.
Well, the other thing that Chille is really guilty of doing is conflating political questions and legal questions. A question of what somebody thinks the law should be is a political question, and a question of what the law actually says is a legal question. Chille very frequently makes these broad claims about what he thinks the law says based on what he thinks the law should be. And that is where I think he leads a lot of his supporters astray in terms of legal interpretation.
And can you guys talk about maybe the potential harm that Chille using those misunderstood or misled arguments can do for some of these people that may have legitimate claims that he may be misguiding?
That's really simple. If he's helping anybody in a criminal defense, that means they don't have an attorney. And if they don't have an attorney, that means that, number one, they're not getting the best legal representation. I mean, the worst attorney is probably better than no attorney at all. And number two, you have a grounds for an appeal if an attorney F's you in the a-hole. you can appeal for ineffective assistance of counsel. If you are representing yourself using sovereign citizen guides that Chille puts out, then you don't have that grounds for appeal. So he's shooting people. He's letting people shoot themselves in the foot by telling them he could do things for him he can't do. And Bobby Law can't do anything for these people. He can't. He's prohibited by every state having restrictions on who can practice law in those states, and by every federal court having restrictions on who can practice in those federal courts.
And the reason that there are restrictions on who can practice law and who can't is that, yes, everybody has the right to represent themselves, and even that is subject to limitation in some cases. But that's because the only person who's legal and in terms of criminal cases, freedom is being put at risk is that person's. If you are, quote unquote, representing somebody else and you aren't an attorney, it's their legal rights and their freedom that's being put at stake, not yours. And so the Supreme Court in every state is the governing body over the licensing to practice law, and they naturally have put restrictions and put requirements on the people who are able to represent others in court, because that's a very serious matter.
So how outrageous is it to you two? And I mean this not just on a professional level, but on a personal level, that Chille de Castro and quote unquote Bobby Laws are trying to influence people right now, like, for example, Great Lakes Audit, Aaron Collins, who's facing multiple fourth-degree felonies and is going pro se on their advice. What do you personally and professionally think about?
I'm still not really big into the drama thing, so I apologize. I think they would be better represented by defense, and especially in a criminal case, if every state has a little bit different take on juries, but if you're facing, I think under precedent, if you're facing more than 6 months, you're entitled to a jury just under the Constitution, due process. And a lawyer for any day in jail. So if you're facing any time in jail, you're going to get an attorney. The court will give you an attorney if you can't afford one. So get an attorney, get a free attorney. A free attorney who doesn't have a lot of time for you is still a free attorney, you know? Right. And I don't like public defenders. Well, let me rephrase that. Public defenders are overworked, and they just don't have enough time to devote the necessary resource to each defendant. And that's just sad. But on the other hand, because they're in court on criminal matters all day, every day, they have seen your case before and they know what to do. So I would still suggest that even an overworked public defender is way better than no attorney at all.
And the public defenders that I interact with on a daily basis, I have a rapport with them. And so it's much easier, I'm sure, for them to negotiate lower sentences than a person representing themselves.
I just want to correct myself real quick, out of fairness to Aaron Collins. I misconflated my cases there. He's facing multiple fourth-degree misdemeanors and 2 first-degree misdemeanors. I misconflated his case with
Ken Freeman. I think
Freeman. Yeah, so I apologize to Aaron for that, but nevertheless, the question, still relevant.
Yeah, and
I don't like
double jeopardy would attach to all these cases he's helping these people with as well, wouldn't it? If they were to lose.
If the state was to lose, then yeah, double jeopardy would attach.
Yeah, if it's criminal, double jeopardy attaches once the jury is impaneled, or in the case of bench trial, once the opening arguments take place. But the civil trials, or cases, I should say, that he's quote unquote helping with, some of them have been legitimately filed, and so there are going to be expectations of Kent Freeman and Yunez down in Texas. They're going to have to exchange discovery. They're going to have to meet in pretrial conferencing. They're going to have things to answer to the judge for as well. And now that Chille is gallivanting all across the entire country, the likelihood of him actually being there to render assistance to them, improper as it is much less likely. And so I wouldn't be surprised if there are times when these people who have the lawsuits already ongoing think to themselves, oh crap, I should probably hire an attorney. And then even if they did, that attorney would be at the disadvantage of having to hop in the middle of a trial, as opposed to consulting with the client, preparing the lawsuit, making sure all their ducks are in a row, and then initiating the lawsuit.
I just want to point out that Juan Galt is in your comment section, and I believe that he has actually argued in front of the Supreme Court. So I don't know why you have a first-year family law attorney up here when you have Juan Galt down there.
We've had Juan on the panel before. Juan is very he's a fan of the show, and we definitely appreciate it. If Juan wants to come up, he's more than welcome to. I can drop him the link.
Brilliant guy.
No, I think it's great. I mean, we started touching on it. We kind of went another direction, but regarding the moral turpitude with Chille, again, based on a layperson, I don't see how we could pass it.
He has a conviction for theft, and like the number one thing, at least in California, the number one thing you can get disbarred for is messing around with client funds, and it's anything messing around with client funds, and you can get the boot. They do not play games about messing around with client funds, and so they got to trust you, and they got to trust you with your client funds, because you might have tens or hundreds of $1,000s of your client's funds in your trust account that you can access. And I mean, if California, they publish all the opinions on all the people who are getting disbarred and things like that, and you just go through it. It's messing with client funds, and so they're not gonna take the risk of letting someone with a theft conviction become an attorney, especially considering he has an ongoing habit of getting restraining orders. I mean, I don't think the restraining orders would in and of themselves disqualify him, but he has multiple convictions from what you're telling me, multiple restraining orders. He's been gallivanting around the country saying that he's a constitutional scholar and an expert and advising people to seek him out to prepare legal paperwork for him, probably violating the laws of multiple states. I'm guessing that what he's doing could be considered practice of law in various states. So the California State Bar is not going. He's not going to make it. Not even maybe.
Right.
Yeah,
He's ran from several warrants that were quashed eventually. He currently has a warrant out for his arrest out of Ironton. Now, the theft charge in his defense was nearly 30 years ago. It was a shoplifting charge. I think it was $50 to $3,000 or something like that, which he did plead guilty to.
A pair of pants.
Yeah. So something even 30 years ago could bar you from passing the moral turpitude portion of that?
I would. Oh, sorry. Go ahead, Merb. Well, I was going to say the thing that I would probably suspect would be the most detrimental to him trying to become licensed in any state would be any potential misconduct that he's done with the money that he's raising through all of these fundraising and Cash App stuff that he does. I don't actually know if any of it is illicit or not, but if any of it is, that's certainly going to result in.
Have either of you seen his newest scam on his website?
Is that where he's offering to draft legal documents for people?
Oh, no, it's where he's charging for legal documents from every state in the union. Hold on, let me pull it up here.
Didn't Mark Stevens get popped for this?
It wouldn't surprise me.
Oh, wait, but it gets better. Wait until you see what documents they are.
All right, let me see here.
And by the way, like one of the easiest documents to draft is your complaint. That's easy. All you have to do is allege facts sufficient that, you know, if the court accepts them as true, then you win. That's super easy. The hard part is all the other stuff, discovery, figuring out what to ask for, doing depositions. I mean, there's negotiating settlements is super hard. So, I mean, yay, I did the super easy thing of drafting a complaint for you. Woo! And now good luck, have fun.
Right. So this is Chille's website. This is Deletes Law's website. You go to the little download tabs, and he has every state listed. That's pretty cool. We'll click on his home state of Alaska. So this is what he's charging for. Demand a return of property, certificate of delivery, $25. A FOIA request, $25. Public information request starts at $25. What is this, Paul or Merb? Certificate of authenticity. Do you guys know what that is?
I don't practice law in Alaska. I have no idea what that is.
Well, he has this in every state. Here, I'll go to another state. You're in California, so
Yeah.
let's see. Cali. Do-do-do-do-do.
I mean, I guess
Yes, nothing. Yes, nothing for Cali. Wow.
Demand for lawful or the return of property would be pretty consistent throughout all states, and that to me definitely seems like a bona fide legal document. The FOIA request, I genuinely don't know whether that would constitute the unauthorized practice of law or not, but
Well, the
demand
demand
for the
for
return of property can initiate a court proceeding.
well, it could be just a demand letter, or it could be in California. There is a specific 1538.5 that is a demand for the return of improperly seized property in a criminal matter. So I don't know exactly what it is.
Well, we're on California now, so this is this.
Okay.
He has the exact same four. He's charged. It starts at $25, and then once you click on it, it goes up to $100 or a custom.
I don't know what he's doing there. A FOIA request. I would guess that most agencies would have their own request formats and procedures. So
Right.
I don't know. Maybe he has a form letter that he's generated.
I don't know. Except I know most states it can be free up to a certain amount of hours or something like that. I just think it's pretty shady charging people for documents that they can basically research themselves.
Well, Merv, I
And-
don't know if you saw, but one of Chille's videos from, this is now several months ago, was him walking into the Ironton clerk's office with a woman from Ironton, and he literally hand wrote what he called a power of attorney.
Yeah.
On like a single sheet of paper, had her sign it, and then tried to record it at the clerk's office, which that's literally the practice of law. Any estate planning documents of any kind.
And a power of attorney just gives her the right to, or him the right to what, dispose of her property or access her bank accounts. I don't know what he's doing with power of attorney.
He stated that the purpose of him doing that was so that he could represent her in her traffic court cases, which also demonstrated that he doesn't understand the difference between an attorney in fact and an attorney at law.
That's common with sovereign citizens. Again, they hear the word attorney, they think, an attorney. Lord.
And Artie's Corporate Fiction did a good job of pulling out the historical references to the distinction between those two all the way back from early modern England and explaining that.
Most states bar you from putting attorney at law in your like advertisements and things like that. Not just attorney. Most states are going to get finicky if you say you're an attorney at law if you're not actually licensed to practice.
I mean, we've had the conversation with Paul several times. I mean, it's pretty blatantly clear that he's stepped across that line of practicing law without a license. And I'm sure he's being, especially in Ohio, because they have a pretty good hard on for him right now. He's got to be being looked at, I would think.
I'm more of a defense guy, so I'd say arguably not. I mean,
well, then this is a good question for you as a defense attorney. Should Bobby Law be identified and pursued by the appropriate authorities for practicing law without a license? Could that potentially, being Chille is involved with him and has led him to people, could that potentially, in a general, non-state specific way, lead to problems for Chille just by association in that?
Well, I guess my first question would be, has Bobby Laws been truly identified? I know there's a lot of speculation of who we think he is, but do we know for a fact that Bobby Law is not a real attorney?
Yeah, we know he's not a real attorney. He doesn't talk like a real attorney.
No, he's not.
He admitted to it. He he had explained that he got his legal education or something to that effect in the same way that the Supreme Court justices from the 1800s did by apprenticing, were his words.
Kind of
Time
sounds like Anna
travel.
Van Wright. Kind of sounds like Anna Van Wright's in Alaska. She's a sob sit from Alaska who was, I can't remember, it's one of Mars Life's favorite people he follows.
Yeah, he basically admitted he had absolutely no formal legal education, and as Merv pointed out, his vocabulary and the terminology, the lexicon he uses makes it fairly clear. And obviously, at some point with his involvement in these cases, there's a high risk that he could be pursued for practicing law without a license, which is why I'm curious how that could come back on Chille on top of what he's doing for having brought Bobby Law to some of these people, or having been quote unquote partners in crime with Bobby Law.
So even though the unauthorized practice of law is in violation of a statute, at least in Ohio, the specific department at the Supreme Court, the Office of Disciplinary Counsel, that investigates violations of that, to my knowledge, acts exclusively on a civil monetary punishment basis. I haven't seen anything indicating that people get jail time for committing the unauthorized practice of law, but they do not mess around with the size of the fines that they will give out for that. Like, I read a Ohio Supreme Court decision that established, because they don't specifically define what the practice of law is, but they do state in the statute that the Supreme Court has the ability to define what it is. And so there was a Supreme Court decision where they ruled that, in Ohio, Supreme Court decision, where they determined that drafting estate planning documents does constitute the practice of law, because a guy who was not a licensed attorney made a will and a power of attorney and a trust for somebody he knew, and they found him responsible for the unauthorized practice of law and charged him $10,000. So they really don't play around when it comes to monetary punishments for that.
Nice.
I would suggest that any liability that Chille might have for Bobby Law's actions would most likely be civil in nature, like where if someone relies on Chille's representations of Bobby Law's bona fides, then they might be able to sue Chille over it. But Chille doesn't have a pot to piss in or a window to throw it out of. So I would also suggest that Chille is somewhat judgment proof at this point. So I'm not entirely sure that Chille would have to worry about either one of them. And plus, he's moving from state to state so fast. I don't know that he really has a lot of exposure out there.
Well, he's living in his van. I mean, what are you going to get from him?
Yeah, and I don't think the feds are going to show any interest, to be perfectly blunt. Even if he's trafficking firearm across state lines and he purchased illegally, I just don't. He's small potatoes, and I don't think they're really going to go after him.
It'd be a secondary charge for the feds. So,
yeah.
I know Murby.
I don't know. Don't you think that fancy self-driving van that he has could be worth something?
Yes. Honda has a new Odyssey van that's self-driving with his knee. So Merb has to dip out on us. Merb, I appreciate you coming up, buddy. I apologize. I was not more prepared for you. Pat kind of dumped this on me. Pat's a dick. And I really appreciate your time. And I do think you have a big brain, even if Desert says you don't. So please come up anytime you want. And
right.
Loved having you up
Thank
here.
you for having me. You guys have a great night.
You too, buddy.
You too. I'll try not to leave too many pejorative against the defense attorney comments in his videos.
Have a good night, counselor.
So, Paul, have you seen the latest? I know you like laughing at Chille because we all do. Have you seen the flat dirt video on Chille yet?
I have.
Yeah, that's probably one of my favorite videos out there. Let's play that for the crowd because there's 400 and some change in here, 350 some change.
Although I will say, I think two of the funniest videos that people have put together about Chille, one was Uncle Artie's finger guns compilation, where it's just like the firing sounds for all of the different title clips of him with his finger guns. And then the other one is Tones' campaign video for Chille running for the governor of Ohio. Those are two of the funniest videos I've seen.
I have not
shout.
seen. I'm sorry. Go ahead.
No, I was just gonna say shout out to Tones because he's been knocking it out of the park lately with his Chille content. The man is getting funnier every day.
This is one done by a page called Flat Derp. They used to deal mainly with the flat earthers and stuff. And someone sent this to me the other night, and the fact they actually did a cartoon of Chille is just priceless. It's only a minute long, so here we go.
I like chicks just as much as any other guy, probably more, because I'm an equal opportunity guy. Black, white, red, green, purple, short, tall, thick. I do them all, baby. I love all women, every one of them. Smells like a woman to me.
This lady's stalking me. She's running into me. Stay away from me. Stay away from me. But she has to understand that she's causing me mental anguish and exhaustion and frustration, and she's being a nuisance. What I'm going to do next is I'm going to defend myself. This woman is harassing and stalking me. She's following me. She's causing problems. She's following me around. She's following me. She's following me. I'm in fear for my life. You better stay away from me, you psycho chick. Stay away from me, lady. Stay away from me. Get this lady away from me. Get away. Get away. I'm telling you, I'm in self-defense, but you better stay away from me.
So yeah, please go to Flat Derp's page. They have got some great videos up there, but that one, I'm sorry, that one just. Oh.
I have to object though, because I was in court and I very clearly heard him say he takes no pleasure in putting his hands on a woman.
Yes, he did say that. I can't wait to get that FTR when Kate gets it, because he did clearly say, I get no pleasure from touching women, and I believe the next line was, they're disgusting. You can't make this shit up. I mean, it's just, he's the gift keeps on giving. I mean, here's another one I want to play. This is for Kate especially. This one did not age well for Chille.
I mean, how many videos can we say have aged well for him?
This one, though, well, here we go.
I'm so scared of you. I'm so scared. You can't beat me up. You can't kill me. You can't beat me in court.
Oops, that didn't age too well, Chille.
Also sort of directly contradicts all of his I'm in fear for my life rhetoric.
Oh, yeah, absolutely. And I do have the racist video. I'm not sure if anyone wants to see the racist video. If you want to see the racist rant from, well, I consider it pretty racist, where he's actually talking to believe someone in your jurisdiction, Paul. The Christopher person.
The Chris Perry, I think his name is.
Something like that. Yeah,
he was like a town council person.
Yeah, and he actually is African American. And
you got to play it now. You got to play it now.
You guys want to see it? I'll play. I mean, I got it queued up. So this one is 4 minutes long.
Well, I thought he did a really good job of calling Chille out on that nonsense.
Oh, I think he did a phenomenal job. I mean, that's, like I said, you can't make this stuff up. I mean, so yeah, I mean, I'll go ahead and play it if you guys want to see it, since I've kind of hyped it up pretty much. So,
and shout out to the creator of it, Faux Shizzle, member of our Discord. She is a badass, a creative powerhouse. Created the intro for the new Matt Soul intro. She is awesome, and this is incredible.
Yes. So let's see here. Is my screen frozen, guys?
Yeah, I think so.
Not playing,
or at least it's still on the end of that last video.
All right, let me. I did change that. Let me see here. Apologize. Like I said, I was looking at it on my phone and my screen didn't look like it was playing the video. Did you hear the audio at all or no?
Nope.
Okay. Let's try take 2. See, that's why Pat can't leave me alone. There we go. Let's try this again. This is only 4 minutes long.
You are for the status quo. You're for dungeons. You're for dungeons. You've never had your asshole looked up. You've never had to turn around, squat, and cough. You've never been put in torture cuffs. You have no idea what it's like. You have no perspective, and you're black, which is even worse. I'm glad you didn't get treated that way.
I'm so glad every 15 minutes you keep reminding me that I'm
Well,
black.
because it's like you forgot you're black, bro. It's like you forgot that you're black. You forgot you're black. The one time the cop pointed the gun at you, you just forgot what that was like to be a black man. Because let me just tell you something. And I'll tell the white people watching too. Being black in America is freaking hell. Especially if you have dreads or you got nappy hair.
Hey, is that based on your personal experience?
What are you talking about? I've traveled the country, dude. I've lived in LA for 20 years, dude.
Is being black in America based on your personal experience?
Yes, it's based on my personal experience.
Your personal experience of being black.
How much time you spent in South Central, dog? How much time? How much time? How much time?
Your dog. Oh my God.
Dude, I know.
How much time have you spent being black? How much time have you spent being black?
When I was in jail, I worked out with the black guy. I almost got killed by the brown guys.
Oh my gosh. You have a black friend?
My best friend was black. And I worked out with a black guy in jail. I was almost murdered, dude. They put me in a circle and said, you're working out with the N'ers. If you ever work out with an N'er again, we will kill you for working out with a black man in jail.
Wow, that's
Have you experienced that? You ever experienced that, Chris?
Have I ever experienced what?
Yeah, going to jail and working out with someone who's not black and then being threatened to be killed. Do you know what it's like to have to join a gang?
Have you ever experienced being black? Hey,
have you ever had to join a gang?
Have you ever experienced being black? Yes or no?
You said you grew up in the projects. Did you have to join a gang or not?
Have you ever experienced being black?
I had to join a gang, and that's very racial. So yes, at some level, not being black skinned, but yes, I've experienced what racism is.
You just said that.
People of color, black people. If you make a hip hop song and there's two different kinds of words, the N with the hard R on it and the N with the A on the end of it, am I racist if I rap the word?
Your leadership sucks. It's zero. You don't have any leadership in the black community. You call someone a racist. Racist is the new N. What I've been doing is looking for a black leader. You don't just take power because you want it. You don't march down the street and say, no justice, no peace, no racist police. It's the most ridiculous thing I've ever heard.
Make sure if you see those two pigs, watch your back. They'll plant guns on you and they'll murder you. Well, I'm sorry. I forgot y'all are black. You already know. The white folks are just waking up.
How did you get my cell phone number?
Oh, bro, we just begun. I told you that, motherfucker. You fuck with the wrong kid, bro. I'm coming to you, bro. You better watch your back.
I'm glad this is recorded.
And then they did it again and again and again. And my people from back home are going to be like, Chille, I told you, you can't help the black community.
Ain't nobody called you. Who called you here? Who called you to help the black community? You said you were recruiting black leaders. Did I miss the memo when we took a vote to call you?
And if you disagree with their political ideology, they brand you a white supremacist. They brand you a racist. A message to you people who made videos about me, I'm coming after you. I'm suing your ass. And I'm doing far more than that. I'll see you in court. They will face a federal lawsuit. You can't do what you do to people and think you're going to get away with it. I'm suing you. By the way, all my black friends right now are making videos. Do you know that? Every black friend I have is making a video saying, I'm friends with Chille. I've known him for this many years. I've had to do it because I don't want people to brand me racist. And now I asked them if I was racist, and they said yes. They said I was racist. Does anybody here think I'm racist? If you think I'm racist, you should unfriend me.
Great job on that, Fishizzle. So, like I said, you can't make this shit up. I mean, he is the gift that keeps on giving.
Well, and he also recently said that young black men are the reason why he started this whole thing. And if you don't mind, it'll just take 30 seconds. I have a clip of him saying that.
Sure, I'll edit it. Let's see what we got here. There's no sound.
Crap.
Good job, Matt. Did you
Damn it. Hang on a second. I'll send you the link. I apologize. I'm an amateur.
No, it's all good, buddy.
All right. Link coming your way.
Alrighty. Let me remove this. Sorry, guys. This is all Pat's fault for leaving me by myself tonight.
I promise this is a legitimate clip. This is not a Cyrax bomb. I swear to God.
Don't mention Cyrax.
I don't think I had a full appreciation of how many bizarre people live in the state of Ohio until I moved here.
Yeah, I didn't until I seen Cyrax, and then Chille came to Ironton, and this was our little
now
town.
It seems like every other news story that doesn't take place in Florida takes place in Ohio.
Yeah, it's either the Florida man or the Ohio man.
Yeah.
All right, so here's what he sent me.
And I've talked about this, but now that I'm just going to focus on exactly what this mission is. It's for you guys to understand the law. That's why I originally started doing what I'm doing. Originally to teach young black men that Terry versus Ohio is killing your communities. That's what I originally made it for. That's why I did it initially, why I created a big timeline. But then I started to share the knowledge of Supreme Court cases that I have.
I don't know if I necessarily consider that racist.
No, but it's ballsy to say that that's the reason you're doing it when you're not black and you're trying to teach the black community what's destroying their community. It not necessarily racist, but it's in the same vein of presuming to tell a community what their problems are when you're not living them.
Well, just like he thinks that he knows more than lawyers do about the law, he clearly thinks he knows more about the socioeconomic issues facing the black community than the black community does.
Yeah, he is narcissist.
Well, that was obvious with the interview he did with Chris. He's talking down to a black man who's been black his whole life, obviously. And like you said, Chille saying, I've lived that lifestyle because I was in jail. And he's amazing. So
and I think the phone call with Chris Perry really threw him off because he seemingly expects every black person that he meets to feel the same level of fiery indignance that he does at the mere existence of police as an agency of law enforcement. And when they don't, he's thrown off. He's like, what? What? To him, that demonstrates that there's something wrong with that person.
And some of the things he says that, may seem just annoying, benign to other people, but borderline on cultural appropriation, like, the sup Playboy and, good God, Chille, just stop. Please stop.
Well, my thing is, he's saying he's helping all these people, and he wants to make this change. And other than raising relatively small amounts of funds, I'm not saying $5,000 or $10,000 is a small amount of money, but that's only going to help them temporarily. He's not going to Congress. He's not going before the state people. He's harassing people. He's not even harassing people anymore, which is kind of cool, I guess, other than the parade. But what has he done to help anybody? Other than saying, Christie spent the money we've seen on fake eyelashes and whatever else she spent the money on. And I just don't. I have not seen him other than a brief financial Jerry Lewis telethon, raise some quick funds for these people, and he moves on. That's not helping people. That's not helping the system. That's not helping make a change.
And the ironic thing about his vehement opposition to a lot of the Supreme Court holdings is that he continually says we need to get executive power to fix this problem, But the check on the Supreme Court declaring something unconstitutional is for the legislature to make a new law, not for the executive to just choose to enforce it a different way. And so by him getting executive authority would not result in overturning Terry v. Ohio like he expects, at least not within the proper way the Constitution is supposed to work. The way he describes using executive power sounds an awful lot like the tyranny that the Founding Fathers did not want to happen.
Exactly. When he went on that whole rant about, I absolutely will have power, I will gain office, I will get authority, it truly sounded like the madman dictator in the Middle East right before a coup. Like, it really honestly sounded like he wants to be a dictator to forcibly make everything the way he, in his fantasy, believes that law enforcement and the judiciary and the law should be.
Well, I brought this up the other night, and unfortunately, not enough people are really calling him out for it. I mean, as much as I may disagree with Freeman about James's political views and stuff, he is a statist. I mean, he's calling for a federal police force throughout the United States. You can put lipstick on a pig; it's still a pig. He wants a federal police force to completely govern the United States.
Right.
And
the Shakespeare quote, that which we call a rose by any other name would smell as sweet. If you take police and just stop calling them law enforcement, but still have them enforce the law against people, you haven't changed anything besides what they're called.
Right. Yeah, it's someone says he's live right now with James Freeman. I thought he was just going over James Freeman's video. I'm all for law enforcement. I'm definitely pro law enforcement. But I said, you're wanting a national police force, but you don't want to call it a police force, and you want these buses driving around. It's complete ludicrous. I mean, I would love to actually talk to him sometime. I know he'll never come on this channel and actually have a conversation, not a debate, just a conversation about his beliefs and his outcomes. And again, what exactly are you doing to help people? Are you going before Congress? Are you going before Senate? Are you going before the city hall and the townspeople to talk about not going from one tragic incident to another tragic incident, and coattailing off of them? And the people that he's getting behind are less than quality characters to be supporting. The one lady, I mean, Christy Arone, I know she has a pretty extensive criminal history. I know the lady who he did the video on that he claimed one of the brothers beat up in Ironton. Her criminal history is pretty outstanding from what I understand also. These aren't stellar characters to, put one's reputation behind and say they were in the right when this happened to them.
And even if somebody has a criminal history, if they suffer injury at the hands of police and they have a legitimate claim against them, by all means, they should be seeking proper legal counsel to pursue a lawsuit if that's the right way to go. The issue is that Chille looks at every situation through his lens of the police can do no right.
Right.
And therefore, if they are at an interaction, they must be doing something wrong.
Mm-hmm.
So two things. First off, I think this is generally my opinion of First Amendment auditors and sovereign citizens, is that their opinions generally seem to be informed by the fact that they have been involved with the police as the consequences of their own poor decisions.
Mm-hmm.
And I'm not talking about during auditing or during sovereign citizen stuff. It seems like a lot of them started down that path because they did something dumb, or they got involved in a bad situation, they suffered the consequences, and instead of taking responsibility, they want to blame the police. Same for Chille, and he's talked about that, blaming his opinions on the LAPD and the search and raid of his house and arrest regarding the drug allegation, which again we now know he ended up with a diversion for. Secondly, I think the thing that aggravates me the most, and I'll preface this, and I've said this numerous times before, I have family that's law enforcement, both in Canada and the United States and the U.S. in one of the most dangerous jurisdictions in America, is that the things he's talking about are not completely wrong. There are problems with excessive force. There are departments and individual officers who are problems that need to be addressed. However, what he's doing is drawing attention away from those problems and turning it on himself. And there can be no solutions when people do that. It's the same thing that, you know, is the effect of sovereign citizens and auditors. They make it so much about themselves that you don't focus on the problems, or it takes attention away from the problems that do exist and do need to be addressed.
Yeah, and support for police and wanting to hold people who are police officers and break the law accountable are not mutually exclusive positions.
No. And like I said, with his Montesquieu and transparency towers, you don't think anyone's going to be corrupt in that at some time or another? You don't think that power will be abused sometime or another? You don't think someone will buy one of the Montesquieus at one time or another?
I genuinely think that Chille, when he envisions the Montesquieu building, it's just like thousands of himself at these various tables.
Mm-hmm. I reminds me of the movie Logan's Run. Yeah, a lot of guys might be too young to remember that movie, but it's kind of like Logan's Run. But yeah, it's like, I mean, corruption's been around from day one, and it will always be around. There will be someone who wants to find an easier way to make money off someone else's labor, skin, whatever it is. And like I said, you know, it's just his lack of awareness is just amazing. Steve, please share with us what we learned in 2 days. And Chris, thanks for becoming a member, buddy. Appreciate it. So yeah, I'm going to wrap this up. We're going on 2 hours. Any last thoughts, guys?
Chille is clinically insane.
I don't think we're prepared to make that determination. That's not a representation from Masswell Report, but he is definitely out there.
I apologize. That is my opinion. It does not represent the opinion of any of the individuals on the panel, Masshole, Kate, anyone. But that boy ain't right.
That's a better way. I agree with you. I mean, there's just something bizarre about him. Let me go over the super chats real quick. Didn't make as much money as Kate, but we definitely appreciate it. Michael, for the Giant Hammer Fund, $5. I want that hammer also, Michael.
$6,000.
Yeah. Ed Merb is in his ruling. The judge actually held Kate as a troll. Yes, Kate has made legal precedence as being a troll. Let's see. Harry, it's a title search. Oh, that was that one document on Chille's website. It's a title search. Thank you, Michael. Again, $5. And then lastly, Chris became a new member tonight. We appreciate Chris, definitely. So
Kate just has to wait until somebody else cites that opinion to have themselves established as a troll, and then she'll really be making court history.
Oh, that'd be fucking awesome. I would. Oh, yeah. What do you see the long-term outcome of the chilliness, Paul?
I mean, I think just like he fled is really the only accurate word, the state of Ohio after his warrant got issued, even for all his grandiose claims about getting Judge Waldo removed from his case and then the warrant quashed, which his legal procedure is not, from my understanding, accurate. I think he will just continue to ping pong between various places, causing the same or possibly even more trouble in those areas and trying to earn as much money as he's able to doing what he's been doing until something, whether it be a criminal charge or something else, really stops him from continuing that course of action.
Yeah, I mean, listen, I can be a little outrageous and say some crazy things, but hyperbole aside, I think I agree with Paul ultimately, both because he's begun to lose the plot and start to buy his own BS, and also because he's burned so many bridges in his life, he doesn't have anywhere to go except maybe Colombia or home to Alaska. He's got nowhere to go.
And
Thanks,
the more publicity he tends to get, especially with things like this case with Kate, the more, or I should say, the fewer people he's going to be able to convince that he is this towering intellect in the legal field. So it's going to be harder and harder for him to convince people, maybe not necessarily to give him money, but to believe that he's going to be a beneficial factor in their criminal or civil cases.
Yeah, see, I kind of differ from both of you. I think he sees this money pit drying up for him. When you watch his streams now, he's definitely not getting the dones he was. He lost 200 subs recently. I think he's going to move on to the next thing. I think he sees not just, I hate using the word community, but I think he kind of like the TikTok thing where he was chased out of. I think he sees that happen. I think it's going to be a situation where the money drives up. People are going to stop realizing he's not doing anything, excuse me, but quick money grabs, and then moving on. Like I said, if he was out there helping people, I might not like him still, but again, he's not helping people. He's not, he keeps saying he's fighting for this change. He's not fighting for a change. He's not fighting for the change is being in Washington and fighting the proper channels, not riding coattails from people who may or may not have been done by law enforcement. That whole breaking the video down of the shooting by the police in Ohio, where he claims the gun was planted. Again, what has he done? And like Ferry says here, I agree. When the money dries up, these people always leave. They do, and that's kind of the path I see him. I mean, look how many videos he's put out in the past 48 hours. He's put out one, and apparently he's going to have some type of tantrum this weekend about Freeman and something else. I mean,
yeah, he claims he's going to debunk all the skeletons in his closet anyone can put out, but public records are public records, and
I was going to say the judge in that ex parte hearing aired some skeletons that I don't know that many other people knew about.
But once it's out there, and you can't hide the truth.
And that's the thing with social media. Like, even if he did the same or similar behavior in the past 20 years in California, burning various bridges with people, the fact that he's been doing so much of this on social media in the last couple of years means people are going to be able to recognize him and recognize the signs of his behavior from further away.
Yeah.
So he has to go to a community where nobody else knows of him or has seen him on YouTube.
But I think that's what he's going to do. He's going to, even if he does move on to the next thing, he's going to keep going community to community and trying to pull his stuff. Because again, I don't think he has anywhere else to go. He's burned so many bridges. He can go home to Alaska maybe, or go to Colombia where he has family. But he's burned so many bridges and scorched earth, so many people, so many friends, quote unquote allies. He ends up pushing a lot of his followers away. That
he's a snake oil salesman.
If he does go to Colombia, I'm very confident he will not be engaging in the same pejorative behavior towards police that he has been in the United States.
Oh, I would hope so. I'd say he'd get a club upside the head. I mean, I've said this before with all these auditors. I would love for them one time to really be put in a country that is a tyrannical government and then come back to the U.S. and have their wine session. The shit that they claim tyranny about is just, what rights have we lost? Filming in a post office. Really, that's the last place I've ever thought about filming in a post office. The whole argument. So,
you guys will find this very ironic and entertaining. So I had a case with a sovereign citizen that there was supposed to be a trial for a contempt charge yesterday. And this guy, at previous hearings, he had worn like the red fez and everything. He had made Moorish sovereign citizen arguments before. And so I was prepared to address all these nonsense claims. But the guy shows up, isn't wearing the fez, and doesn't even make any sovereign citizen arguments. And when he's discussing his past history, he had mentioned that he had applied to work at a post office, which struck me as really ironic because
oh my God,
he was a sovereign citizen.
Did he bring a copy of Poster 7?
He did not, but I didn't call it out in the courtroom, but I was just thinking to myself, like, my God, what have we come to when
Yeah.
somebody who espouses sovereign citizen ideals is willing to work for the U.S. Postal Service?
Yeah,
that moment as an ADA where you realize you're about to have to argue over an Oxford comma on a government poster.
Yeah, so the court is just asking their questions, and I'm over there having an existential crisis of, my God, do I really know anything about sovereign citizens?
I would love to see if any Sov Cit has ever won their case. I mean, I'm pretty sure I know the answer, but it has ever won their case using the Black's Law. And I'm pretty safe to say it's no.
No, no sovereign citizen has ever won a traveling as opposed to driving
Right.
case on the merits. They have certainly been dismissed. They have been nolle prosecuted before because the
Right.
prosecutors have better things to do, but no sovereign citizen has won their traveling argument case on the merits, meaning another sovereign citizen can cite to that case as support for their argument as well. And that's why it just doesn't develop into a cohesive legal argument.
No.
Yeah, I think the sovereign citizens who haven't been convicted, it can be summed up, like Paul said, non-prosecuted or dismissed. It can be summed up in a single sentence from the prosecutor and the judge: go away.
Well, they take that as a victory. They think that as they beat the system.
It's a victory in the sense that they escaped any consequences, not
Right.
that they created any substantive case law in support of their principles.
Right.
But it's becoming so common now that it's just the judges and the prosecutors, and I think Paul will agree, a lot of them are just like, it's not worth the time.
Well, it's also much like Chille as far as his GHB arrest. I heard him make the statement that I beat that case. No, you didn't beat the case. You weren't found guilty of the case, but you did not beat the case. Right. He was given a 2-year diversion program. But in Florida, it's called PTI. I got in some trouble when I was a kid. I was like 21. Florida's was pretrial intervention. You're a good kid for a year. They dismiss all the charges, and you have no conviction. That's not beating the case, though. It's a first-time offender program. Doesn't mean you beat the case, Chille. You took a 2-year diversion, and the case was dismissed. Again, you didn't go before a judge, and it wasn't a bench trial. It wasn't a jury trial. You took a plea. So
the goal is to prevent the person from causing more trouble for a period of time. And if
Right,
you
and
didn't get
reoffending,
in trouble
right.
for 2 years, then the state accomplished its goal in that regard.
And the state may or may not have gotten something from him in return, potentially, too. You don't know.
No, we don't. I don't want to make that speculation because we have no proof of that.
And that's why I'm saying that's why I'm prefacing the documents aren't available or anything.
Right.
But he, there was a plea there. There was an agreement there. It is what it is.
So anyway, let me wrap this up. I'm going to answer James Rice's question. James has been spurging about Glenn for 2 nights now. I'm assuming James Rice probably is Glenn. We actually haven't talked about Glenn in months. Actually, Glenn did take a plea also in his Mecatio case and had to write a letter of apology, James. How he beat the other cases, talk to Tyler Klein. She's one that follows Glenn the most. I got tired of Glenn. But we haven't covered Glenn in a while. So James or Glenn, whoever you are, that's pretty much it, buddy. That's why we have to talk about Glenda. But you were spurging on him last night, and now you're spurging our chat again. So piss off.
Let's be honest. As much as he runs his mouth or ran his mouth when he was out, the letter of apology is actually probably worse than him having to sit in a cell.
Oh God, yeah, that crushed him. I think Pat's working on getting a copy of him. He has some insight with Mecatio. I'd love to see what color crayon Glenn used when he wrote those apology letters. Telecline, thank you, Fizzy. But yeah, so anyway, wrapping it up, guys. Appreciate you guys spending your night with me. It's a Wednesday night, and I'm sure we'll be back sometime this weekend with more Chille nonsense because he is the gift keeps on giving. I know Fairy likes hearing about Chille, so we want to keep Fairy happy and give her all the Chille she can handle. So anyway, guys, good night. Appreciate it, and we'll talk to you guys soon. Have a great week.
Thank you very much for having me on.
Anytime, buddy.
Later, everybody.